Our next legal maxim in law of tort is qui facit per alium facit per se, which means he who acts through another is deemed in law as doing himself. The reasoning is that a person who puts another in his place to do a class of acts in his absence necessarily leaves him to determine according to the circumstances that arise when an act of that class is to be done and trust him in the manner it is done. Consequently, he is answerable for the wrong of the person so entrusted, either in the manner of doing such an act or in doing such an act under circumstances in which it ought not to have been done, provided what is done is not done from any caprice of the servant but in the course of employment. So this very maxim decides that whenever you engaged or employed some other person on behalf of you to do certain acts, then you would be responsible for the omission or commission of any such act which would held to be liable under law of tort. So the very maxim qui facit per se is relating to the very idea of law of tort, that whenever you employs any person or engaged any person to do certain acts of yourself by that person, then the very consequences of such acts done by such person, if it would be held liable, then the liability will rest on the person who engaged or employed such person to perform or to do such acts. So the very maxim qui facit per alium facit per se deals with these responsibilities which rest on the person who employed and engaged another person, and his acts, omission or commission of such acts, if would cause any liability, then the liability would be rest on the very person who engaged and employed that person.